In this conversation, we'll talk briefly about healthcare information interacting with the legal system. And it is, of course, a bit of a frustrating area for many healthcare administrators, and that police and lawyers and prosecutors are always wanting information, and they're always waiting you to go down to the courthouse and so forth. So the goal of this conversation is to take some of the angst out of that, help you better understand some of the terminology. We will cover this from a different angle in our medical malpractice section, but this is intended to give you a bit of an overview. We'll talk about civil litigation, we'll talk about workers' compensation, we'll talk about criminal investigations, and then we'll also talk a little bit about prisoners that may be brought to your facility, or you may be providing services in a facility. Let's first look at civil litigation. You may receive a request from an attorney for records. That if it is solely a request from the attorney, you should reject it probably. It needs to be an authorization by the patient to release those records to the attorney, and most attorneys will, of course, send a copy of that with their letter asking for a copy of the records. Frequently, you are going to be receiving in the HIM department subpoenas. Those subpoenas will identify the case, will identify the patient, as is described in your textbook. That subpoena should also give notice to the patient if they are not a party to the lawsuit that their records have been requested, and that there is a period in which a patient or someone else can file a motion to quash. That's with a Q, not a S, motion to quash. It's because of producing the records would be improper for whatever reason they want to articulate. Virginia recently passed a statute that permits the authorization of records as business records so that a member of the healthcare HIM department does not have to trudge down to court and say the magic words of, yes, these are the records that we keep in the usual course of business. You'll quite often now see a subpoena will have with it a form that someone at HIM can complete that says these are our records, they are kept in the usual course of business, and they sign that in the presence of a notary, and therefore no one has to go down to court to authenticate the documents. Billing for copies of records is always an ongoing stress. You'll see the schedule set forth in your textbook for records that are subpoenaed. That is provided for by statute. That is different than the fee schedule that you can charge for a patient to obtain their records when they simply request them from you. The requirement for billing for records provided to the patient is that you charge a reasonable charge for what is actually incurred. And the folks at OIG and OCR contend that that is much lower than what that fee schedule is that the state has set forth for what you can charge for subpoenaed records. You may also see, if you are a party to litigation, a notice to produce records. Your attorney will help you with that. In essence, that is simply the request by the opposing party for you to produce documents, and that may include healthcare records and so forth. There may be certain objections that your attorney wants to file as part of that. So stay with your attorney and let them work with you to figure out if any objections need to be filed. There is a short turnaround for that those objections must be filed within 21 days of your attorney receiving that production request. Workers' compensation sets things up on an entirely different relationship quite often than what one would have with a normal patient. It may be that your healthcare providers are doing independent examinations of patients or of workers, either at the request of the employer or at the request of the workers' council. In those settings, there is a different sort of relationship than the traditional doctor-patient relationship. That information is often not quite as confidential as it would be in other circumstances, in that it is shared with the Workers' Comp Commission, it's shared with other parties, and so the providers need to be aware of why the examination is being done and to who the results are to be distributed to. It also gets quite often complicated in that a provider may kind of get into the workers' compensation system because a worker seeks out their care for a work-related injury. They may or may not disclose that on the front end, and the physicians often protest that they really don't want to be involved in workers' comp. They don't want anything to do with it. Well, unfortunately, it is a bit of a challenge, because if you want to be paid by the Workers' Comp Commission for your services, then you have to cooperate in providing records. So you can't turn up your nose and say, sorry, I don't do workers' comp, unless you want to do it for patient care for free. So it is important that your providers understand that there is a requirement to participate in providing their records, in completing reports and so forth, if they wish to be paid either by the Workers' Comp Commission or by the insurance companies that insure the employers in these settings. We'll talk briefly about criminal investigations. That is going to be a separate discussion under police inquiries. But for the moment, if you are receiving inquiries from the police or other settings, make sure that you understand the foundation for why that is being requested. The police officer should be able to give you a warrant if they are seeking information. It's always easy to ask the question, why do you have a right to this? And as one can appreciate, that may not be a relaxed conversation, but it is an important conversation for the police officer to articulate why they have a right to particular information. If a grand jury is requesting your PHI, they should again be providing you with a subpoena for that. Some jurisdictions that may be referred to as a summons to appear before the grand jury. It is important that you, of course, consult with counsel so that the parameters of what it is that you're being asked to disclose, you are comfortable with that and don't need to file any objections. Your friends at CMS may come in on Medicare or Medicaid audits. They have a number of different instruments and ways to obtain your information. It may be by a subpoena, it may be by an administrative subpoena, it may be an investigatory process. One of the challenges is that if you agree to participate in Medicare and Medicaid, you also agree to cooperate and provide information. So it gets a little bit difficult. An important distinction for you, just so you can be hip at cocktail parties, is the difference between a search warrant and a subpoena. A search warrant is issued by a magistrate or a judge, depending on what state you are in, and that is issued after someone appears before them and says there is probable cause that the information that you have will lead to an arrest for a crime that has been committed. A subpoena may be both in a civil case or a criminal case, and that is simply a order by the court for you to provide information, either written documents or verbally at some point. And those are issued in most jurisdictions not by appearing before a judge, but by simply an attorney signing those. Either a search warrant or a subpoena may be quashed by the court if good cause is shown. And so it is, again, important that you take time and have your counsel review such documents if you have a concern about what may be produced and why. You may have prisoners brought in from either the local jail or from a prison to your facility or to your offices, and then you are going to have questions or inquiries from the correctional officers as to what took place. The challenge of that disclosure is that prisoners still retain their rights, even though they are prisoners, to the extent that it can be maintained in comparison to the warden or the official running the correctional institution has a right to any information that is necessary to maintain order in the facility. And that may be for the protection of the patient. It may be to protect other prisoners from that patient. And so, again, it is a minimum disclosure sort of standard, but the patient's right to protect their health information is limited, but not totally prohibited. The prisoner retains the rights to protect confidentiality for anything and everything that is not necessary for maintaining order in that institution. And that is sometimes a challenge because, again, the default is simply hand over all your records to the correctional institution. Making that scenario even more challenging is that you may be asked to see that prisoner by the in-house correctional health folks, and you are providing records back to that organization. In that setting, you would correspond with that correctional health physician or with the service as you would with any other healthcare provider under any circumstances. It is then up to them to make that decision about what is appropriate to share with the administrative side of the house based upon what is necessary. That concludes our conversation about healthcare information in the legal system. I encourage you to look at the textbook for a much more in-depth conversation about this important topic. As an administrator, you're going to be asked a lot of questions, and it's important that you be able to field those or at least be able to refer those to counsel when it's important.